So my name is Casey McCall-Smith, and I'm the director of the Global Justice Academy. And we are extremely pleased to welcome you today to this sandpit event that is coordinated between the Global Justice Academy, Strathclyde Centre for the Study of Human Rights Law, the Newcastle Forum for Human Rights and Social Justice, and many of our other partners in the Northern UK Human Rights Network, including Durham and a variety of other partners. So today, what we are trying to do is to help people develop their responses to the Ministry of Justice consultation, which, if anyone has been paying attention to social media, at least human rights heavy social media and lots of civil society discussions, the consultation paper really puts forward ideas that are very contrary and will have an absolutely devastating effect to human rights as we know them and enjoy their protection under the Human Rights Act. So today we have a top panel on various aspects of the consultation, and they're each going to offer about 6-7 minutes of input on different aspects of the consultation. And so I'm going to try and keep time quite quickly so that we can have a few minutes for discussion at the end or for questions. We are also collectively, this group, along with the panel from yesterday and quite a large range of academics that are not actually speaking on the two panels, we are developing a working document that we'll be sharing next week in case anyone wants to develop their own consultation response and just doesn't have time to be an expert in everything, which none of us do. So without further ado, we've got a slight change to the speaking order because Helen Terrell is going to join in after Dr. Lewis Graham, who's going to speak first. I'll introduce each speaker at the outset and then go in order after that. So first, we have Dr. Lewis Graham, who's going to kind of give us some opening notes on the consultation. He's a fellow in law at Wadham College at Oxford, where he researches and publishes in the area of human rights law. So Lewis, you have the floor.
That's great. Thanks so much, Casey. Can I just confirm that you can hear me okay? Perfect. So I don't want to risk information overload by going into too much detail in the nitty-gritty of, particular cases and particular statutes, because I'm hoping to put the more specific information in this document that we're hopefully going to circulate. But I just want to mention a couple of points about the consultation process and then about a couple of questions in particular. My main kind of headline point is to note that I think we should be pretty skeptical of the government's claim, of the Ministry of Justice's claim, which is repeated throughout the consultation document, throughout the government's comms on the project and some of Dominic Raab's sort of statements to the press, that this reform exercise is in any way sort of based on the extensive consultation period which led up to this kind of almost second consultation. So the Ihra, the IHRAR, Independent Human Rights Act Review, conducted sort of a year-long study, essentially taking into account expert voices from all kinds of sectors across the political spectrum, across kind of legal positions, and published quite a robust report. Now, I don't think that report was perfect, and I don't think that report is, without criticism, but it was, fairly robust. And the government claims that this report kind of fed into or led to the current consultation and certainly the current proposals. Now, both documents are very long and very laborious, so maybe just take my word for it instead of reading it start to finish. The two do not match particularly closely. There are certainly some things, in the Ihra report which have sort of leaked into the consultation. A focus on sort of public education, a focus on transparency, a focus on accountability in Parliament, things like that. There's an overlap, if not a direct sort of echo. But there are so many things in which either the original Ihra report said nothing on, or even worse, the Ihra report said, hey, don't do this. And the Ministry of Justice is now pushing ahead with it. So just by way of example, I'm going to talk in a second about Section 2 and Section 3 of the Human Rights Act. In relation to both of those sections, the Ihra panel said no changes needed. They're working kind of as intended, more or less, and we do not recommend changing things in this area. The panel said similarly when it comes to secondary legislation and treating secondary legislation differently from the way we treat it now. The panel said don't fix that. It ain't broke. And the government has went against that and is pushing for some kind of change there. And there are also so many aspects of the consultation, the new permission filter, right to a jury trial, limiting positive obligations, a lot of the deportation stuff. None of this was really even considered in the Ihra report. So whilst I suppose you could say that the Ihra panel didn't recommend against those changes, they certainly didn't advocate them because didn't even consider them, so they didn't consider them necessary. So that's my main kind of point. I just want to say beware of any kind of claims to legitimacy or claims that the government is just following the experts or following the advice of this expert panel, because by and large it's not. And it may be legitimate for a government to say we're going to reject the advice of an expert body, but it needs to sort of be honest if it's going to do so. A couple of very quick notes on one or two of the specific questions relating to sections of the Human Rights Act. The question 1 and question 2, and I won't tread on Ellen's toes here, but relate to the position of the Supreme Court and the position of the European Court of Human Rights. And my main message I want to give away here is just that, again, I think the government mischaracterizes this relationship and suggests that it's something that it's not. And a lot of my work that I've done recently has been sort of to unpack and examine what our courts are doing in relation to judgments of the European Court of Human Rights. And again, I'll put the details in the shared document if people are interested in looking at these further, but broadly, our courts are pretty comfortable with departing from Strasbourg where they don't want to follow it. And they do this for a variety of reasons. Some of them seem pretty sound to me. Some of them seem pretty off to me. But regardless of whether you think those cases are right or wrong or justified or unjustified, our courts can, if they choose, say no to Strasbourg and completely go in the opposite direction, different direction of travel to that which Strasbourg is taking. So, when the consultation is asking, should we ensure that our courts are the ultimate arbiter of human rights, and should we, give two fingers to Strasbourg? I think, we're already kind of capable of doing that. So I think that's a bit of a non-starter. In terms of section 3, I just want to mention a bit of research that's been done by Stephanie Needleman from Justice and Florence Powell, and they've essentially looked at the use of Section 3 in practice, as opposed to kind of the rhetoric that we see both in judgments and from the government, and they conclude, perhaps surprisingly, that Section 3 is just not as powerful a tool as some, even textbooks perhaps suggest. Although it allows kind of quite creative interpretations and quite extensive statutory interpretation, in practice it's used very modestly, very carefully. And I think their kind of takeaway point is that judges are very, very aware of the possibility of misuse of that power, the possibility of being seen to go too far with that power, and they're being very cautious in their creativity. And I put links to that study and key takeaways in the document we just mentioned there. And finally, I just want to mention there's a sort of proposal to treat delegated legislation or secondary legislation in a different way to the way we currently do. And I think that is question number 15, largely. Should the court be able to make a declaration of incompatibility for secondary legislation? Now, I think this has echoes of some of the government's proposals in the Judicial Review and Courts Bill, where these are being framed as lovely new tools for judges. We're increasing discretion, we're creating flexibility. And if that's the case, that sounds great to me. Having more tools in the arsenal, probably not a bad thing. What I worry is that what the government's really getting at is they don't like the idea that secondary legislation could be invalidated or quashed by courts. And they're kind of pushing towards just issuing a declaration of incompatibility rather than issuing a quashing order. And that would be a very different kind of situation. The whole point of a declaration of incompatibility is that it signals to Parliament that something ought to be done, something could be considered, and it doesn't affect the validity of that legislation. And that quite sort of unique mechanism is done because of the sovereignty of Parliament, because of the importance of parliamentary supremacy, and tends to work quite well. The same obviously doesn't apply when we're dealing with secondary legislation. And if we replaced, or either we replaced the power to quash secondary legislation, or we, for example, made a presumption in favor of a declaration of incompatibility rather than quashing, this risks, allowing the government to get away with breaching human rights laws under the same, using the kind of justification that we currently ascribe to Parliament. And obviously government and Parliament are very different in terms of what we might think they should be able to do with human rights. So we should just be very careful with too light a touch an approach to secondary legislation, I think. And again, I've added one or two just the cases or citations in that wider document. So I don't want to say too much, and I think Ellen is going to supplement those points and add some of their own and make them much more eloquently than I can. So I'll end my session there.
Okay, great. Thank you, Lewis. I look forward to looking at all of the different points of information that you've added to the document. Next, we have Dr. Helen Terrell, and she is a lecturer in law at Newcastle University at the law school. Her book, UK Human Rights Law and the Influence of Foreign Jurisprudence, was published by Hart in 2018. She gave oral evidence just last month to the Joint Committee on Human Rights on the subject of the government's proposed Human Rights Act and British Bill of Rights reforms. So you have the floor.
Thank you, Casey. I'm really sorry to anyone who's just joining. I've got a really croaky voice, but I hope that everyone can make out what I'm saying all the same. So I'm going to try and keep my points really brief and not repeat things that other people have or would be likely to say. I'll start with question 1. I just have one point to add there. I'm going to distill essentially my book into 30 seconds, which I don't think is a really good sell, but I'm going to do it anyway. Essentially, what I want to say is that question 1 asks whether courts should be able to draw on a wide range of law when reaching decisions in human rights cases. And they're thinking particularly about referring first to the common law and then also looking at the law of other domestic courts in other countries, for example, Canada, Australia, the US and so on, rather than just looking at the Strasbourg case law as a first resort. Now, the point here is the domestic courts are, of course, already able to do this. This isn't new information for the courts. They're able to draw on a wide range of law in reaching their decisions. Since it's not binding, the case law of the Strasbourg court is still only really technically persuasive, and it's one of a number of persuasive authorities, even if it is more persuasive because of the way that it helps to interpret that instrument in particular. And it's true that Section 2 requires courts to take into account that jurisprudence where it's relevant. So it puts a positive obligation, I suppose, on the courts, but it doesn't prohibit courts from taking into account decisions of other courts. A little bit of data from the book, 533 cases were handed down during the first 8 years of the Supreme Court's work. I read every single one, it was disgraceful. And then 152 of those I thought could be categorized as quote unquote human rights cases, insofar as you can draw that kind of category. And then in those, 38% of those cases included references to foreign law, as in foreign domestic courts. So it's over a third of the court's diet there that judges are referring to those other sources of law that go beyond the Strasbourg court. It's not something that doesn't happen. And of course, it can provide a valuable perspective. So more on that in more hundreds of pages in the book if you really want. I'll put something more detailed into the document. Then there's the point about secondary legislation that Lewis was just touching on there. I'm really worried about the government's suggestions here. I'm not going to dwell too much on the risks that it poses to the balance of powers between institutions of state, because I think that others might speak to that later. But of course, there are a few specific points. First, the proposals would limit the ability of the courts to provide immediate remedies for violations of convention rights anyway, because as Lewis said, a declaration of incompatibility is discretionary in that it triggers a power, not a duty, for a government minister to amend incompatible legislation. So it can be ignored. Now in practice, declarations of incompatibility are not ignored, and that said, not many are made, and the courts also importantly have a discretion themselves about whether to make one, even where they have found that there is an incompatibility with legislation. So there is potentially a bit of a knock-on effect here. So some people say that declarations of incompatibility have become quite a powerful tool, partly because not many are made, so when they are made they get listened to, and also partly because the judges are able to not make them, so again it lends force when they do. That could be an obvious casualty if we're to make declarations of incompatibility more automatic, because it will vastly increase the number, you would think, of declarations of incompatibility if the courts are limited to issuing those in respect of secondary legislation. Now that's hypothetical. More significant, I think, is that it makes the treatment this proposal makes the treatment of secondary legislation different depending on whether a case is argued on human rights grounds or ordinary public law principles, because of course the courts presumably would still be able to quash secondary legislation where it falls into unlawfulness on ordinary public law principles. So that's bizarre. And then it also, more troublingly, creates disparities, I think, between Westminster and the devolved nations. Any legislation passed by a devolved legislature, so in Scotland, Wales, Northern Ireland, which is not compatible with the convention, would be deemed to be outside the competence of that legislature. So the courts could quash that attempt at legislation on the basis that it's incompatible with the convention and so outside of their competence, unlawful. Restricting courts to a declaration of incompatibility in respect of secondary legislation, as in removing their ability to quash that legislation, would bizarrely raise the status of secondary legislation made by ministers in Westminster above the status of purportedly primary legislation passed by the devolved legislatures. And I think that's really one of the big troubling things about that particular proposal. I can stop there because I'm conscious of time. Also, I feel a coughing fit coming on.
Okay, great. Thank you so much. That was great. Good timekeeping as well. Okay, next we are going to move swiftly toward our next speaker. Dr. Dimitrios Kagieros is an assistant professor in public law and human rights at Durham Law School. His research focuses on the ECHR and the protections of freedom of expression. So Dimitri, you have the floor.
Excellent. Thank you so much, Casey. So I'll be focusing on question 6 of the consultation, which reads, what further steps could be taken in the Bill of Rights to provide stronger protection for journalists' sources? Now, I thought this was quite an odd question, as Article 10 of the Convention, it's the Convention's free speech provision, already seems to be working well when it comes to protecting journalists and their sources. There are, of course, areas for improvement, but what I at least will argue in my response to the consultation is that such improvements should be achieved by updating the specific legal frameworks that protect journalists and whistleblowers domestically, rather than by altering the language of Article 10 in the British Bill of Rights through the addition of further specific protections for journalist sources. But just to examine this in a bit more detail, so the protection of journalist sources is one of the components of press freedoms that are protected under Article 10 of the ECHR. And the protection of journalist sources essentially has 4 interrelated components. So first of all, Article 10 prohibits authorities from requiring journalists to disclose the source behind their reporting, unless there is a compelling overriding public interest in doing so. Secondly, Article 10 prevents authorities from searching the journalist's workplace or home and seizing journalistic materials without good reason. Thirdly, Article 10 requires states to introduce safeguards when carrying out mass surveillance or bulk interception of communications to ensure that journalistic sources are not intentionally or unintentionally uncovered in the process. And finally, the sources themselves, so whistleblowers, are protected under Article 10 from retaliation they can face when they disclose to the press information that is in the public interest. Now, in relation to the first 2 components, so the confidentiality of sources and the seizure of journalist materials, there doesn't seem to be any compelling need for reform. So domestic courts have been successful in protecting these aspects of press freedom by relying on Article 10, the case law of the European Court of Human Rights, but also on domestic law. So the Contempt of Court Act, the Police and Criminal Evidence Act, all offer protections along those lines. When it comes to the third component, mass surveillance, now the UK was recently found in the ECTHR in violation of Article 10 for not adequately protecting journalists' communications in the context of mass surveillance. However, newer legislation that has been adopted has added more safeguards, although we still don't have a very clear idea of how this has worked in practice. But in any case, what I will argue is that any improvements should be made within this act rather than adding any sort of text to the existing language of Article 10 of the Convention, as it will be reflected in the British Bill of Rights. Now, the final point is that free speech also protects whistleblowers, so individuals who report wrongdoing to the press. And here is where things get even more odd for me. So the government, in the context of another consultation on official secrecy, has proposed increasing penalties both for whistleblowers who disclose official information and also for journalists who publish this information. So there seems to be some inconsistency here with the Human Rights Act consultation's stated purpose, which is to strengthen free speech protection for journalists and their sources. So I plan to sort of point out this incongruity between the two consultations, but overall argue that any changes, any improvements should be made to the existing framework rather than adding anything to free speech as it is understood in Article 10 when this provision is copy-pasted into this British Bill of Rights. And that's it. Thank you very much. I don't know how much time I took.
Okay, great. Wow, we're just rocking along there with keeping to time. So that's great. It means we will have more space for discussion and questions. So that's great. Thank you so much. And next, I am very pleased to introduce Nicole Busby, who is a professor of human rights, equality and justice at the University of Glasgow. She regularly advises the Scottish Government on equality and human rights law and policy, and was a member of the First Minister's Advisory Group on Human Rights and chair of the Academic Advisory Panel of Scotland's National Task Force for Human Rights Leadership. And I can say that she did an amazing job as chair of that group. So you have the floor, Nicole.
Thanks very much, Casey. Sorry, I'm a bit croaky as well. And thanks to everyone who's gone before. I'll try not to repeat anything that's already been said, but I agree with everything that everyone has already said. So you'll have gathered from the introduction that I'm based in Scotland, and I think it's true to say that there is unanimous agreement across Scotland that the reform of the Human Rights Act is completely unnecessary. There are many reasons for this, not least the fact that it's potentially damaging to the current devolution arrangements. I won't go into that just now, but will do in the response to the consultation. Furthermore, the proposals contained in the consultation, if enacted, would pose a serious threat to access to justice for many of the most vulnerable individuals and populations in our society. So I'll focus on that issue today. The whole consultation document is framed from a starting point that assumes that the Human Rights Act has gone too far and that change is required to restrict it and to rein it in. This is simply not true. The recent independent review that we heard about from Lewis earlier on, commissioned by the UK government, whose panel consulted widely, found no evidence to support this position. In fact, the review panel recommended that the UK government should seriously consider the development of an effective programme of civic and constitutional education in schools, universities and adult education as a means of raising awareness about human rights. The balance to be struck between such rights and individual responsibilities. Rather than positive and proactive approach to the existing rights framework, which was envisaged, I think, mainly by the review panel, the UK government's current consultation adopts a regressive and negative framing, which assumes that what is needed is the dilution of current human rights protections with the imposition of additional barriers to accessing justice and a separation between how those rights are interpreted by the European Court of Human Rights and the UK's domestic courts, a sort of decoupling. If the proposals contained in part 2 of the consultation are enacted, access to justice for many would be severely curtailed. So I'm going to focus on questions 8, 9, 10 and 11. Question 8 asks whether there should be a condition that individuals must have suffered a significant disadvantage to bring a claim under the Bill of Rights as part of a permission stage for such claims, and whether this would be an effective way of making sure that courts focus on genuine human rights matters. So the assumption there is that they're not doing that currently, which, as I've said, if there's evidence, please show us of that. Question 10 asks how else could the government best ensure that the courts can focus on genuine human rights abuses? And question 11 seeks views on how the Bill of Rights can address the imposition and expansion of positive obligations to prevent public service priorities from being impacted by costly human rights litigation. Costly there is referred or used to refer to the costs for public authorities, including the UK government itself, rather than the often prohibitive costs faced by individuals dealing with breaches of their human rights. So central to the UK government's vision is its attempt to restrict access to the proposed Bill of Rights for those individuals wishing to bring claims or cases. To do this, it proposes a new permission stage at which the individual would have to show that he or she has suffered a significant disadvantage before a human rights claim could be heard in court. This, it is claimed, would have the potential to make sure that the courts focus on genuine human rights matters. The possible effect or potential effect of this would be to shift responsibility to the claimant then to demonstrate that their claim is worthy of the court's consideration. The framing of this proposal presupposes that lots of vexatious and spurious human rights claims are currently being heard by courts across the length and breadth of the UK. No evidence is presented in support of this, and if such evidence does indeed exist, why wasn't it presented by the UK government to the independent review? Furthermore, the consultation doesn't provide any specific proposals regarding how the process would work in practice and which sorts of claims it would apply to. So the detail is lacking here, and that actually makes it very difficult to respond to it in any detail without speculation. I think this is the problem with quite a lot of the framing of the questions in the consultation document. The obvious concern is that a permission stage would place additional barriers to justice for potentially vulnerable individuals who simply wish to claim their legal rights. Certain aspects of the consultation do appear to overlook the pre-existing provision of the Human Rights Act. We've heard about that already, as if little attempt has been made to consider how things currently operate. For example, how does the suggestion that claimants should suffer significant disadvantage match up to Section 7 of the Human Rights Act, which already includes the victim test for standing provided for by Article 34 of the Convention, which incidentally has been criticised as too restrictive in terms of who can bring a judicial review and how it might proceed in a range of contexts, including in unseen crimes such as domestic violence. Ultimately, then, it seems likely that if enacted, these reforms would discourage or maybe even prevent cases from being brought before domestic courts. This would be wholly regressive and an unnecessary step, which would undermine the intention of the Human Rights Act as a means of bringing rights home, in which I should say it's been very successful. It should be speculated, or could be speculated rather, that the effect of this will be that more cases are taken to Strasbourg. But that's not a feasible option for many, given the high costs involved. What is more likely is that only a small selection of cases will make it to the European Court, diminishing access to justice for most people with disproportionate and potentially discriminatory impacts on some protected characteristic groups, disabled people, migrants, women, etc. It's certainly possible that these changes will be accompanied by associated cost rules, if enacted, which will be rationalised, I'm sure, as necessary to prevent spurious claims. And in that, I can't help but recall the government's previous attempt to prevent claimants from bringing cases to the employment tribunal by way of a fees regime, which was found to be contrary to the rule of law by the Supreme Court in the Unison 2017 case. So I would say that before any decision is made to introduce any changes which will restrict the routes offered by the Human Rights Act for cases involving potential breaches of the Convention to be heard by domestic courts, the UK government should conduct a full equality impact assessment so that any disproportionate effects on specific groups can be identified as a first step. And in conclusion, I would say that the consultation reveals, I think, so many potentially alarming possibilities for the future of human rights and access to those rights that it's difficult to know where to start. But I'll try and do my best in the consultation response and in the document that Casey has mentioned. And I'm sure that for many of us, responding to another consultation is the last thing that we feel like doing at this moment in time and have the time to do at this moment in time. But I think that if we care about the future of rights and the ability of individuals to access those rights, we really must do so robustly and in the strongest terms. I'll finish there. Thanks.
Okay. Great, thank you, Nicole, and you absolutely nailed it on the head. You nailed it in that, you know, it's really important for as many people as possible to respond to the consultation, and that was kind of the theory behind having these events. That it's just absolutely disgusting what the government's trying to do, and the impact that it will have on those who most need the protection of human rights. Okay, next we have Elizabeth Laughlin, who is an assistant professor in public law and human rights at Durham Law School. She teaches on public law and human rights modules and researches in the fields of comparative constitutional law and English administrative law. So Lizzie, you've got the floor.
Thank you very much. Thank you to Casey and the team for pulling us together, and thank you also to my fellow speakers today. So I'm going to talk about question 13 and 14 together. So question 13 is the one about how could we enhance Parliament's role in engaging with and scrutinising Section 3 judgments. And question 14 is on whether a new database should be created to record all judgments that rely on Section 3 and interpreting legislation compatibly. These questions stand fairly unusually in the consultation in that they do actually align somewhat with suggestions made by the Ihra report panel in their report. I understand they don't necessarily seem at first glance the most controversial questions in the consultation, but I do nonetheless think they require some quite careful thought. So on 13, the Ihra panel's primary recommendation was for improving Parliament's role was to consider expanding the Joint Committee on Human Rights terms of reference so that they would enhance its, in order so that they could have a role in enhancing scrutiny of the role of Section 3 judgments, essentially, enabling parliamentary scrutiny of Section 3 and allowing the Joint Committee on Human Rights to report upon that as well in their role. That has advantages, I think. It would help dispel misperceptions about the use of Section 3. It would also enable maybe government and Parliament to consider practical implications of Section 3 usages. Not a bad thing, maybe intervene if necessary. I would say on that, though, a note of concern might be that expanding the Joint Committee's role in this way, you need to ensure that it's still properly resourced in expanding this. This could be a really legitimate concern. So they also, of course, still need to be able to perform their vital functioning of scrutinising every government bill for its compatibility with human rights. So if we add this into their work docket, what are the implications of that? So that's something that I will likely draw attention to in the Durham's consultation response. In respect of question 14, should a new database be created on Section 3 usages? The Ihra report made the following practical suggestions on this. They suggested that the courts, government and Parliament, and particularly the Joint Committee on Human Rights, should work together to put in place a system or database for identifying superior court judgments across the UK that rely on Section 3. They suggested superior courts sensibly to make sure that any database wasn't unmanageable or unworkable and keeping on top of. Fair enough. And they suggested that only judgments should be included in this database where Section 3 is used to interpret legislation and it has or could have made a difference to the court's interpretation. They're the only judgments that should be included. So in principle, I think my position is that I welcome this idea. It would give much needed transparency to the ways Section 3 is being used by the courts. It would also likely help dispel concerns about the ways the interpretive power of the courts is being used in this space. And also, this highlights something of critical importance, these two questions, I think, actually, for the sake of this consultation, which it reminds us that actually at present, there is a lack of evidence supporting the government's proposals in respect of Section 3. So questions, 13 and 14 highlight that we need the evidence base first before we move to make some of the changes that are recommended in question 12 or were invited to talk about in question 12. That being said, although I offer support, it's not unqualified. So in Durham's submission to the Ihra report panel last year, and also in Justice's submission, which Lewis already mentioned, Florence Powell and Stephanie Needleman's work here, we both conducted quite similar empirical exercises recording the ways in which Section 3 have been used in a data set of case law. And what that experience tells us is that gathering the information about how Section 3 has been used so far is not actually a particularly simple task. So it could be that any suggested database, again, we don't know what this is going to look like, but a suggested database could be forward-looking. It might record all Section 3 uses after the potential creation of a wider remit for the Joint Committee on Human Rights. That might have benefits. It means the courts going forward might be more transparent about in their reasoning about how and when they're using Section 3. That doesn't seem too controversial to me. However, such a database will only be forward-looking. That might not capture how Section 3 has been used in the past. And the problem with that is it might mean that dissatisfaction with whatever interpretive power remains going forwards continues to rumble on. So there is still value in having a more complete database, I think, that is backwards looking as well as forwards looking. That has methodological challenges that I think are worth highlighting. So, and the way I want to highlight this is by comparing the experience of Durham in an empirical exercise and Justice in an empirical exercise here. So Justice did a much more complete analysis than the Durham team. They looked at 593 cases handed down between the 1st of January 2013 and the 31st of December 2020. Durham, for reasons of practicality, we only looked at judgments in the High Court of England and Wales from January 2011 to December 2020. So our data set came out to 112 cases. In terms of findings, we come to very similar conclusions in our interpretation of our findings. When analysing our data, both teams found that when Section 3 is used by the courts in recent years, it's always done so in a way that's not particularly radical and always aligns with parliamentary intention. Probably not news to many of us. However, our numbers differed. So over the 8 years that Justice looked at, they found 25 out of 593 cases where Section 3 was used to interpret legislation compatibly. Durham found 17 out of 112 cases. So given that our database is much smaller, that seems like quite a large number actually. So how do we account for that difference? Looking at the two sets, it seems that we included uses where Section 3 was merely used to provide support for a finding that could also have been found on ordinary statutory interpretation, on an ordinary statutory interpretation basis, whereas Justice discounted and separated off that category. That didn't end up in their final number. And for me, therein lies a little bit of a difficulty in a database looking backwards, because the courts are not clear often on how they've used Section 3 in the past, even though it's not coming across particularly controversially. They sometimes conflate what they're doing. They might say, for example, Section 3 requires me to interpret the legislation this way, but also I would have interpreted it this way according to ordinary statutory interpretation rules. So is that a use? Is that not a use? I would say that's not necessarily a problem for the creation of the database, because all you need is for the database to be open about its methodology. But the risk might be that this creates a numbers game in which there is a number used about Section 3 usages that becomes quite headline grabbing. I think that's something that's also worth kind of just considering, that could be a risk. I'll stop there. Thank you.
Great, thank you so much. You were going on such a roll, I hated to even stop you, but I'm looking forward to reading more about it. So this is great. So much useful information that's coming out from everyone. I'm really I would love to say I'm excited about responding, but the fact that we have to is somewhat, well, entirely depressing. Okay, next we have Douglas Jack. He is a teaching fellow in human rights law at the University of Strathclyde. He teaches various human rights law related modules at both the undergraduate and postgraduate levels, and his core research relates to the third way model of human rights protection, evaluating whether and how this model operates in the Scottish context. So Douglas, you have the floor.
Thank you very much, Casey, and thank you very much for initiating such an important project. Thanks as well to all the other speakers. So I'm going to focus today on question 18 of the government's consultation document, and that relates to section 19 of the Human Rights Act. So the government wants to know how that provision is operating in practice and whether there is a case for change. So my broad conclusion in this area is that section 19 has definitely led to some positive improvement for the protection of human rights in the UK, but it has failed to live up to its promise as a provision that would lead to effective parliamentary scrutiny of government legislation. Now, I think that research kind of indicates that this isn't necessarily down to the design of section 19. It's more down to the nature of the UK's political system. We know that the UK operates according to the Westminster political system, where we have a government kind of dominating parliament, and we have kind of highly centralised political parties, which kind of determine how parliament operates. So I don't think necessarily there's much that could be done to reform section 19 in itself in order to improve this parliamentary scrutiny of legislation. But one thing that I think this conclusion does lead us to think about is some of the assumptions that are made in some of the other questions in the consultation. So I think that particularly part 3 of the consultation, which is all about this kind of rebalancing between the courts and parliament in terms of the protection of rights, that's kind of based on this assumption maybe that parliament will be able to step in to the role that the courts currently kind of occupy, and that the parliament will be able to kind of properly scrutinise government legislation. And I don't think that that is necessarily the case. I think the operation of section 19 probably tells us that's not necessarily going to happen. So for that sense, I think, for that reason, I think that maybe we should resist these assumptions and these proposals in the government's consultation. So I'm going to kind of broadly try and set out the case for this in the rest of today's presentation. So for those of you that don't know, section 19 of the Human Rights Act requires the person in charge of a bill to issue what is known as a statement of compatibility. What this essentially means is that the minister has to say that they are satisfied that the legislation that they're proposing to Parliament is compatible with convention rights. They may also issue what is known as a nevertheless declaration. This is where the minister is not satisfied that their legislation is compatible with convention rights, but they nevertheless aim to proceed with that legislation. Now, section 19 has had some positive effects on legislation in the UK. I think as a result of section 19, there's lots of evidence that there has been significant changes to the way that bills have been developed. We know that there is quite detailed and robust vetting for all pieces of legislation on convention rights grounds. And this has kind of 2 benefits. Firstly, it means that a government's legislation is in itself, the aims are kind of likely to be compatible with convention rights, that often it will be drafted in a manner that means that it is overall compatible with convention rights. It also means that it's very unlikely that when a minister introduces a bill to Parliament, that the government will not be aware of the rights implications of that legislation. But one of the areas where maybe there was an aim for section 19 where it's not fulfilled that aim is in relation to the aim that it would lead to effective and enhanced parliamentary scrutiny of legislation on convention rights grounds. Now, there's quite a few different reasons for the kind of ineffective scrutiny that I just described. One of the reasons is that we know that despite these kind of detailed compatibility assessments that happen pre-introduction and during the bill's development, that governments are still willing to take risks with legislation, that potentially would be, that they know themselves might be challenged and successfully challenged on convention rights grounds. But despite being willing to take these risks, they aren't necessarily willing to admit that to Parliament or to people beyond Parliament. So they don't tend to issue these nevertheless declarations. They tend to kind of hide behind maybe confidential government legal advice and say, we consider that this bill is compatible with convention rights. Now, there's been a few things that have happened to try and mitigate that kind of maybe incongruence between findings of incompatibility and the government statements. One is that Cabinet Office guidelines have changed, I think during the Cameron government, to require more extensive reasons given by government to justify their decision or that the legislation is compatible with convention rights. And these more kind of detailed assessments do assist the Joint Committee on Human Rights in their scrutiny of the legislation on convention rights grounds. And the Joint Committee on Human Rights does, as Lizzie kind of referred to, play a very effective role in kind of assessing legislation on convention rights grounds. Having said that, despite there being quite a lot of information available for parliamentarians to scrutinise legislation on convention rights grounds, we know that that information doesn't tend to lead to a change in terms of the practice of parliamentarians when it comes to bills themselves. And again, this can be explained kind of by two factors. The first is that the government is generally quite resistant to any amendments to legislation that would try to improve its compliance with convention rights. And the second is that so far political parties, so oppositions generally haven't found a convention rights lens as a kind of useful lens through which to base their scrutiny of government's legislation. So I think what we see here then is a situation where we do have quite a lot of information available to parliamentarians, but that doesn't tend to lead to effective scrutiny of legislation on convention rights grounds. And as I said earlier, I think this is more of a structural problem rather than anything to do with design of Section 19 itself. I think it's down to the nature of the operation of the UK Parliament. And I don't think that any change to Section 19 would be something that would fundamentally alter these dynamics in itself. That's a different issue. It's something that would take a lot more kind of reform than just reforming Section 19. But what I think my observation or other people's observation of Section 19 in operation does tell us is that some of the assumptions in the rest of the government consultation, which is all about this kind of rebalancing of the protection of human rights in the UK away from the courts and more towards Parliament, that because we know that Parliament so far isn't really able to fulfil that role, then it's quite a dangerous thing to take away the one area where we know that the role is being fulfilled effectively, which is through the courts. So I think for me, the main conclusion I'd like to just draw, and I think we've got good timing for that, is just what we see from the operation of Section 19 is that there's a real danger in weakening other protections, namely judicial protections of convention rights. So thanks very much for that, Casey.
Great, thanks, Douglas. That was very clear and gave us some good context for further responding to this document. And last but not least, we have Allison Seaman, and she was called to the bar of England and Wales in 2003 and is currently pursuing her PhD at Edinburgh Law School. Her main areas of practice are civil actions against the police, mental health inquests, and human rights law. So Allison, you have the floor.
Thank you very much, Casey. And I'm conscious of the time, so I shall try and rattle through what I want to say. I'm going to be focusing on Section 2, so questions really 1 and 12, and the sort of proposal. There's two proposals that are being put forward by the consultation paper in terms of amendment of Section 2. But just to remind everyone, Section 2 is actually titled The Interpretation of Human Rights. And as we all know, what was said is that the courts must take into account judgments, decisions, or advisory opinions of the European Court of Human Rights, the Commission, or the Committee of Ministers. The proposed amendments, and I'll come on to why I think they're quite radical, are quite radical. First of all, the option 1 is to make clear that the courts are not required to follow or apply the judgments of the ECHR, and that the meaning of a right in the Bill of Rights is not necessarily the same as the meaning of a corresponding right in the ECHR, and that courts are required to follow any binding precedent of our domestic courts under the Bill of Rights, so not under the HRA or anything else, but under the Bill of Rights when deciding a human rights question. And courts may have regard to relevant judgments from other countries and international courts outside the UK. And I'll pick up a little bit on what Helen said earlier. Option 2 is no less radical. It well, first of all, it isn't radical because it reinforces that the Supreme Court will have ultimate responsibility for interpreting the rights under the Bill of Rights. Well, yeah, of course. But it does say will have particular regard, and this is quite worrying, to the text of the rights set out in the Convention and to travaux préparatoires of the Convention. So again, making clear that the courts are not required to follow or apply any judgment of the European Court of Human Rights. So there's a clear intention here is to, in effect, dismiss or certainly demote the judgments of the Court and the Commission at the European Court of Human Rights, and imagine, to all intents and purposes, that all that exists is the words of the Convention. Obviously, the UK was quite important in terms of the drafting of the Convention. So you can see here the government saying, well, it's fine to look at the travaux préparatoires. So essentially, I think trying to take us back to where we were when the Convention was first drafted. But where to start with these changes? Well, I think that a lot of the consultation paper, and I think maybe this is something we might want to think about, I think is legally illiterate in terms of what they're actually trying to say should be happening. And it's also like to produce results that are completely at odds with the aims and the general kind of thrust of what the consultation says it's trying to do. And again, I think maybe that is a better way to attack some of this than maybe coming at it saying that, you know, it's a populist decision, they're getting rid of our human rights, but maybe more of that later. Anyway, before considering a little bit more detail about the proposals, I think it's worth emphasising just how radical this change is. I think as others have said today, the purpose of the HRA was to bring rights home. And I think it's more accurate to say to bring convention rights home. It enabled UK citizens, enables UK citizens to get redress before our domestic courts for a breach of convention rights. So the whole kind of coupling between the domestic law and domestic remedies and the convention. And the intention was to stop the vast majority of cases going to European Court of Human Rights to save costs and to save time. But it not only gave a new cause of action in the domestic courts, but it also provided for the interpretation of domestic legislation and the common law in accordance with the Convention. So it provided a domestic remedy to a breach of convention rights, and it also ensured that there was going to be an alignment between domestic law and the conventions. And that was the whole rationale behind the HRA. And these proposed amendments actually turn that completely on its head, and it seeks to decouple the domestic rights and convention rights, and it breaks that tie. It's no longer about providing a domestic remedy for breach of convention rights, and it's no longer about aligning our domestic law with convention law. But at the same time, this is where I think the kind of illiterate nature of this proposals are, we are to remain part of the convention. And it's to remain the fact that people can take an individual case to the European Court of Human Rights. And I certainly don't see how these two things can actually work side by side. My view is that it's either going to lead, if these proposals are taken up, it's either going to lead to complete chaos or actually nothing. Nothing very much is going to happen. But anyway, looking then at why I say that these changes wouldn't actually even seek to achieve the aims that the consultation paper puts out. I think those aims really are to row back on mission creep, whatever that is, to halt the continued application of positive rights, to rebalance protection between the courts and Parliament, and to allow Parliament to retain greater control over the content of rights, to reduce the cost of human rights litigation, reduce the number of cases, and create more certainty. So if those are the broad aims of the consultation paper, I'll suggest that none of these would be achieved by these proposals. In actual fact, the complete opposite. So first of all, the proposal would create, I think, more uncertainty and certainly be more costly. The current section 2 of the HRA is very clear. It's very easy for the courts and for lawyers to follow. There's a clear hierarchy of sources of law, and there's a boundary as to what the relevant law is that the court should take into account. The proposals, I suggest, will create real uncertainty. In terms of the sources of the law, so you've got sources other than the ECHR, I think there's at least 4 major issues with this. Firstly, it's almost limitless in terms of what the sources of law can be. And I do think this will be a field day for lawyers. And for those of us who are around when the Human Rights Act came into force, you may remember it was said that the Human Rights Act was going to be a field day for lawyers and for crackpots. Well, I think this is potentially a field day for lawyers. Lawyers will search high and low for helpful jurisprudence around the world. There's much less consistency, I think, in the meaning and the content of right across the world than there is in terms of the European Convention of Human Rights and domestically. There's very different legal cultures, different economics, different public interests. So to kind of go far and wide to find the content of these new rights, I think is likely to lead to uncertainty. Secondly, they require the Supreme Court, I think, to determine what the hierarchy of sources is going to be. And essentially the options set out a kind of new code as to what laws can be looked at. Will we sort of look to common law jurisdictions? Are they going to have more persuasive powers, or are we going to look to countries with similar cultures, similar economies? Which cases from which jurisdictions are going to serve to be more relevant and more influential on our courts? Thirdly, I think cases will be more drawn out. I think more cases are going to get cited. I think there'll be more arguments, including arguments as to which law is more relevant and why. And what happens, fourthly, if the domestic courts follow a line of cases in another jurisdiction, then there's subsequently changes to that jurisdiction. I'm sorry about the timing. So would we then have to follow the new jurisprudence? Would it unsettle then our the case law within our own jurisdiction? I pick up and I accept what was said by Helen in the sense that it's already the case that the courts can look to other jurisdictions. I think the problem here is that tends to happen at the Supreme Court level. Obviously, there's proposals that go across the whole of the jurisdiction. So it wouldn't only be the Supreme Court where people might be using cases from other jurisdictions, but I think it would go wider than that. So just to summarise, I think the proposals are trying to, I think, take us back to a pre-1998 case law, starting with the text, and that in itself is going to create real uncertainty. I think it's going to also mean that we won't have so much control over the development of rights at the moment. Obviously, the UK can intervene in cases in the European Court of Human Rights and does so. There is a dialogue between our courts and the ECHR. So it's bounded, the kind of application and the way in which we look at the way rights have been interpreted. It's got clear boundaries. And there is a clear ability for domestic law to influence the changes under the ECHR. It's not going to stop mission creep. I think, in fact, it's going to increase, lawyers are going to become more adept at using other jurisdictions. It's not going to stop the use of positive obligations. That's an established part of human rights. So wherever you look around the globe, I think you're going to find positive obligations. So in short, it's going to create more certainty. It's going to be more costly, more litigation, less control. The mission creep is going to be an expansion of rights. We are going from a very clear bounded approach to one that's very wide open. As a practicing barrister, bring it on. As someone who cares about human rights and cares about the rule of law, absolutely no way. Anyway, I shall end there. Sorry for going over time.
That's absolutely fine, and was a great little bang at the end. I think that was a great way to end it. We have reached our hour, but if anyone has any burning questions or comments, I'm very happy to take us a few minutes over, but a very limited amount of time over, because I know everybody has other obligations throughout the day. And so, yes, so if anybody wants to make any last comments or anyone has any questions, you can raise your hand. I think someone has, oh yes, Gavin, please.
Hi, I'm so sorry for joining late, by the way. I just saw this on Twitter and joined as soon as I saw it. Very much enjoyed that, Alison. I mean, yeah, I think short-term chaos, but I think the Supreme Court will feel it will have to clamp down on this very quickly with authoritative rulings limiting the kinds. I mean, people citing the First Amendment, for example, in free speech cases would be pointless, and I think the Supreme Court will fairly rapidly. I think try and control it. I think the uncertainty comes from they will at the same time feel there has to be some sort of nominal change. They can't just ignore this and just treat it as if it was just Section 2, which you kind of could, because if you go in a strict law through all the clauses, virtually all of them don't actually change the law formally speaking. But there's obviously a shift in emphasis, and I think the courts will be left with something they have to in some way acknowledge this and at least, you know, change what appears to be their approach while wanting completely to avoid the chaos that you suggest could result. And Lord Carnmouth's talk is very clear that he says, you know, judges will despair at saying that like anything can be cited, it's all up in the air, we don't know what it means, we have to go back to square one. Obviously they will not want to do that on rule of law grounds, amongst others. So it'll be a lot of work, but I think it would settle down after the Supreme Court. But to what? I don't know, because they've got to try and do something with this, I think, but at the same time not allow for the chaos that you suggest would result if they took it really seriously.
Yeah, those are great points. I don't know, Allison, if you want to come back, but Gavin, I saw you join in quite in late, but we have recorded this, so we will make that available, and I'll tweet it out as well. So does anyone else have any other comments? Allison, do you want to respond quickly?
Well, absolutely. Obviously, the Supreme Court would be there as a break, but to get a case to the Supreme Court, the time it will take a long time to settle down. I mean, I feel that, having started practice at the beginning of when the Human Rights Act came in, up until now, we've just about got to the point where things are settling down. You no longer come across a judge now in a court who says, what are all these human rights? But you do still see real misunderstanding. I mean, there's a decision of the Court Protection Judge recently who completely misunderstood the derogation and thought that the courts could derogate, and it wasn't something that the government could derogate. So it's taken us 20 years to get to this point when we had a very clear set of rights set out by the European Court of Human Rights. So to say now we're going to open it all up again, it will take a huge amount of time to get the Supreme Court to, and it will be, you block up the Supreme Court. You're going to take all the cases there to get it settled down. So I do fear for chaos, I have to say.
Yeah, and I see Connell has his hand up. So Connell, go ahead.
Yeah, sorry. Thanks very much. Thanks, guys. I found today really informative, and it's been very worthwhile in educating me in some of the areas that I haven't looked at. My point's basically just about how we're going to bring in the travaux préparatoires into this, because it just seems utterly insane that we're going to trade elusive case law from the European Court of Human Rights from present day for 8 volumes of a really vague discussion from the late 1940s and 1950, and that we're somehow an immediate pre-World War II society is going to be the go-to ahead of our present understanding 70 years later. It just, I have the travaux in the house because I'm looking at it in respect of Article 1, and it is so inconclusive on so many issues that it just seems like it's being held up as some type of mythical source that is going to be of value whenever it really isn't. Absolutely misguided nostalgia for the era. If you can drop Churchill in to a sentence, then you immediately derive more authority, perhaps. But to turn that into a question, if anybody working on different areas of and who've looked at the travaux, if you see greater certainty, I'd love to hear. So yeah.
Allison?
Yeah, sorry, one of the bits that I've missed out of what I was going to say is actually the other really worrying things is the fact they're saying we're not going to follow the HRA decisions. And I think that underlines exactly what you're saying, Conor, in the sense that this really is trying to take us back to where we were before 1998, and as you say, even earlier than that. And I don't know, and that's the other area. I don't know how we're going to suddenly ignore all the decisions we've had under the HRA, which have obviously been premised on the interpretation of the rights since their inception and not, going back to when it was drafted. So the whole thing's just a mess, I think.
Yeah, I'm going to just come in on this, and then we'll try and close this up. I'll take advantage of my role as chair. But I think your question on the travaux, every time I use them, which I do a lot, particularly in my work on reservations, but it is to point out how unhelpful they are. And I think you're right. And I think that this is nonsense because those existed in a time when we didn't have connectivity in the way that we do. We didn't have all this technology. We didn't have such a globalized world. So this is nonsense to think that those documents exist in a vacuum and can't be touched by any of the decisions that have been made, as Allison said, in the past 20 years. So let's hope that someone that will be speaking on the floor of Parliament will consider what we've said here, and in all of the responses that will no doubt be pouring into the response to the consultation. Not that they have promised to publish them. So, I mean, why do we need transparency in governance? That would be crazy. So I think what is important is that we make a tide change. And in fact, one of the things that we were talking about in our civil society meetings this morning for Scottish Civil Society, talking about incorporation, is that we might develop a repository for all of the responses to this consultation in case the government refuses to publish publish them. That way anyone else can access them once they come back with their responses, so that we'll actually know what people responded to the consultation and be able to point to the fact that the consultation, they didn't listen at all. So what's the point of a consultation if in fact that's what happens? But I want to thank all of you for speaking today. It was brilliant to have you, and those of you who spoke yesterday. So Connell, it's great to have you here again today, and Elizinda. I think there have been so many really amazing points, and there's such a rich, collection of information that will no doubt come through in this working document, which we will share with everyone who registered for the event. And I'll put more information about that on the Global Justice Academy's website as and when it's available next week. But I just want to thank all of you for responding to my calls to speak on these issues, because I think it's really important that we all band together and draw attention to just the utter nonsense that the government has come up with in terms of what their idea of human rights are, and or their idea is, and what are the changes that they think we need to make us have human rights. We know what our rights are, and we all think about those and defend them and fight for them every day. And I think that you've all made that clear, that we all have something to say. And I hope that this event, its recording, and the document that we produce help as many people as possible respond to the consultation. So thank you all, and have a great afternoon.